We've heard a lot about the Cobell Trust lawsuit and its proposed settlement. We're here in Madison, Wisconsin with Professor Richard Monette, who's has a little bit of concerns about that. Richard, you want to tell us a little bit about your recent testimony in Congress about why you raised some issues having to do with that potential settlement?
My biggest concern for the settlement is that it essentially ignored tribes. It was hatched quickly by the teams, the federal government, and the plaintiffs. It was then sent quickly by the judge to Congress with a deadline for Congress to act. And the numbers in the settlement were higher than the numbers that the court itself reached a couple of months ago, actually in December, in its close to final disposition of the case. And so just the mere fact that it basically went so fast raises concerns. The fact that it did so without consultation with the tribes themselves, tribal leaders, raises concerns. The fact that the amount of money on the table is higher than what the judge ordered also raises concerns. The fact that the judge wanted it to go quickly raises concerns. So all of those things that raise concerns should bring us to the table to look at this in light of the way other sort of class actions have evolved, settlements have evolved. I mean, these are new things for Indian country. And maybe this could be a new development that is an exciting and positive one, but these are not new in America. There are all kinds of concepts that come into play that frankly I think the haste here wanted us to overlook. And so I've asked those questions, and quite frankly I don't think we've gotten very good answers. Let's make sure we clear the air here. Cobell was about a corrective accounting. It was about simply reconciling accounts. So in fact, as we were told early on, the genius of this is that we were not asking the United States for any money. And so it wouldn't raise those kinds of red flags up the flagpole of asking for money. We were simply saying, if an account says it has $100 in it and it's supposed to have 500, correct it. You're not paying out the 100. Nobody's asking you to pay out the 500 either. Just correct the accounting. And of course, a lot of this was based on the knowledge that the BIA didn't have the records to do that. But if it had asked for money, the sovereign immunity of the United States would have been on the table, which is why it wasn't a request for money. That's why it was simply the court sitting in equity and being able to mandate by injunctive powers to order the United States to do a corrective accounting. As soon as it became asking for money, of course, that required a waiver of the United States sovereign immunity. So that's why we go for 14 years without money being on the table. And all of a sudden this turns into a request for money, and it's hurriedly sent to Congress for Congress to waive its immunity after the fact, not before. If it had been waived before the fact, we might have gotten a more robust record on this issue developed, but it was after the fact. Now do it quickly, and run it through before anybody. When we have a judge that wants to ram this through and a deadline passes, okay, let's set another one, and that passes, now we should start to ask, what is it that the judge has here that is sort of self-interested to get this done? Number one. Number two, the second that the dollar amount went over what the judge ordered $455 million. The second that was $455 million and $1, right? It should have raised a couple of questions in our minds. What is the plaintiff offering more than what they had on the table before that justifies that extra dollar? Number two, what are the defendants getting, the United States of America getting, that they're willing to pay more than what the judge ordered? Those questions need to be asked and answered with clarity and certainty. And now I'm saying $1 more than $455 million. The fact of the matter is it's $1 billion more. So what are the plaintiffs giving up that they didn't win on in court? And what are the defendants getting? What is the United States of America getting out of this, right? That they're willing to pay $1 billion more than the court would have ordered them to pay. $1 billion is, still substantial. Maybe not so much to some people these days, but still substantial. And the thing that they are getting primarily is a settlement of claims that are based not on money, but on the administration and management of the asset themselves. The oil, the gas, the coal, the timber, the water, none of that was ever part of this lawsuit. It was not what they filed for. It's way beyond the reconciliation of accounts. It's way beyond the question of the historical records. It's the Cobell plaintiffs, Cobell side, and maybe just Cobell with their lawyers at this point, putting something on the table that they didn't have the right to put on, and the defendants saying, we like that you put that on, let's settle it and clear the table. And who's losing again? All the unnamed plaintiffs, all the Indians out in Indian country losing on this issue, and neither one of them had the right to do that. These issues were not litigated, as you say. There's no robustly developed record on them. The fact of the matter is, if Congress wanted to say at some point, you know what, we recognize there's all kinds of claims out here, and so we're going to appropriate $1 billion, offer every native $500 to take it. If they don't take it, okay, their claim will survive. Congress could have done that without the Cobell suit. They could have done that at any time, and then without taking $100 million of it and paying lawyers. At any time, Congress could have done that. And they certainly could have done it without a record, which is what they're doing now, without a record on what these claims stand for. And in some tribes, those claims are minimal. In other tribes, those claims are huge, where individual allottees have claims for utility lines running through their property, oil has been extracted without their consent, all kinds of skimming of oil. Congress held a whole Senate Committee on Investigations exercise about, almost 20 years ago now, talking about oil companies regularly skimming oil and all that. Those are the claims that this settlement is purporting to settle, without talking about them, without litigating, showing us no records whatsoever. And that is, frankly, it's unconscionable. Getting here is sort of, they lost in the court. The court ordered $455 million and then said that an accounting could not be done. It goes to the appeals court, and the appeals court says $455 million is out because we believe accounting can be done. Okay? Once we're at the appeals court, this should go to the U.S. Supreme Court. Why wouldn't we use the full exhaustion of the federal judiciary to decide this matter before Congress steps in? I mean, frankly, we got Congress here as playing along, acting like it's tribal council. We got the Cobell plaintiffs acting like a lot of tribal members do. I'm losing in tribal court. Quick, let's run to the tribal council and get them to bring politics in. That's what we have here. Let's avoid the federal court here because we're losing. So let's run to Congress and have them step in like the tribal council. This should be exhausted in the federal judiciary. If we lose, fine, we lost in the appeals court anyway, and here we are with the fancy settlement. So if we lose in the Supreme Court, here we can be with the fancy settlement afterwards. But let's put all of this on the table first, where it belongs. Let's build a robust record the way we're supposed to. One of the, there is the class action, the Federal Class Action Settlement Act, 2004 or 5. Of course, there are federal rules of civil procedure that do a lot of things, but one of the things that they do is to protect absentee plaintiffs, absentee class members in these class action lawsuits. And certainly the Class Action Fairness Act is intended to do that. Essentially, the settlement is asking Congress to move this through in an exercise of its plenary power so that those laws, the Class Action Fairness Act and the federal rules of civil procedure, don't have to apply. And that as well is unconscionable. Let's recognize that when what the federal rules say, and the Class Action Fairness Act supports, when a settlement puts more money on the table than the last best decision of the judges would have put on the table, $455 million and this $1 billion or $2 or $3 billion more, depending on how you look at it. When that happens, the judge becomes an even greater trustee for the absentee class members to make sure that there isn't collusion among the named plaintiffs and the defendants, exchanging goods and their lawyers getting exorbitant attorney's fees behind closed doors, and the real class, the absentee class members, being forgotten about. And that's what looks like is happening here.